Thank you, Dan, for joining us today. It's a great honor. Dan Priel is an associate professor at Osgood Law School at the University of York in Canada, and will help us today to make sense of Nance's jurisprudence. Dan, you have the floor.
Great. Thank you very much, Andreas. And thank you for the other organizers for helping make this happen. And thank you, everyone, for joining. So just as I said minutes before, I actually convened this forum some years ago. I think, although I'm not sure that this is the first time I'm joining it since I convened it. So it's especially special. I wish I could have presented it in person at Oxford, but unfortunately, as we all know, it's not happening. But there are some advantages, like, for example, the fact that I can use some slides. So even though I'm definitely following the structure of the paper, the themes and the main ideas of the paper, I've decided to present it in slightly different way from the way the argument is presented in the paper, partly maybe not to bore myself, maybe because of limited time. So I'll start by kind of situating the paper, and then I'll get to the main course, which is my reconstruction of the work. And so that's the first part. So in terms of, kind of explaining who I am and how I get to the paper, who I am in terms of my views on jurisprudence. So I'm actually, whatever that means, I'm not a Dworkinian. So I have quite significant differences from working in the sort of broader outlook on law and the world. And if I am something, if I had to kind of choose a label, then I would probably choose Benthamite. So naturalistic, anti-moral realist, consequentialist, and scientistic, which is sometimes used as a kind of a derogatory term. But I think science is great, and the world would be better if its methods would be extended further. So that's and that's not quite what you know from Dworkin. So what it means for me in terms of jurisprudence. So I'm against the entire project of conceptual jurisprudence, and I'll say a bit more about this later. And I'm opposed to the recent trend, if it can be called that, and sometimes called the metaphysical turn in jurisprudence, when people are trying to kind of identify the ontology of law or something like this. I don't think that's a viable project, let's say. And I don't think that there is some kind of special question of explaining the normativity of law that is distinct from explaining the normativity of football, for example. And if you think, and as I think you should, that there is a straightforward naturalistic explanation for the normativity of football, then I don't think that there is a particularly compelling reason to think that that account, whatever it is, would not be a good account for the normativity of law. To the extent that there is a difference between football and law, and there is one, it has to do with the fact that law is coercive and its norms are imposed on people without their choice. I say something about this in the paper. And that means that there is a question of legitimacy that does not exist or is different in the context of football. But that's not a metaphysical question, that's a political question. So I do think, and I don't think there is any problem for a naturalist to be concerned with political questions of political philosophy, of political theory. And so that's sort of my broad outlook. And so why do I write the paper on Dworkin? Well, partly because, as I say in the paper, Dworkin, whether we like it or not, remains a significant figure in contemporary jurisprudence. And therefore, I think it's worth getting him right. But perhaps more surprisingly, at least as I read him, he's actually a friend of both points that I just made. So he's definitely, as I read him, an opponent to conceptual jurisprudence in all its forms. That's one of the main points of my paper, to say he's not a participant in it with a slightly different view, but rather an opponent of the whole project. And he's also, perhaps here there may be some differences between him and me, but ultimately he's also someone that I think that's quite clear from his very early writings, someone who wants to see legal philosophy and political philosophy combined in some way. And so perhaps for this reason, I found myself agreeing with Dworkin more than perhaps one would expect. Possibly that's because I read him through the lens of my own perspective, but I will try to show you today that my perspective has some basis in his writings and makes sense. Now, I'm not going to speak, the paper does not speak at all on question one. I am going to speak today briefly in my remarks about question one, but my paper is much more on question of these 2 points on question two. So that's the background and sort of how I came to write this. And now I get to the paper itself. And so, as I said, my organization of the presentation is slightly different from the paper itself. Sorry, it's somewhat different from the way Dworkin presents his argument, right? So, for example, the most notable example for Dworkin, the whole argument from theoretical disagreement appears very early, right? So, if Riggs versus Palmer appears both early on in taking right seriously and very early on in Law's Empire, whereas in my account, it appears at the very end. I think my organization kind of makes it clear, but I also recognize that there are different ways of sort of, there are many moving parts here and they can be sorted out in somewhat different ways. So that's one thing. The second introductory remark, which I think must be kind of borne in mind throughout my presentation, is that I think many legal positivists have sort of domesticated Dworkin. And so they thought that he accepts their general understanding of jurisprudence, but has a disagreement at fairly small levels. So one way of putting this, they thought that he disagreed with them on the criteria of legal validity. I say no, his disagreement was much more profound, and therefore his challenge to legal positivism and perhaps the whole way the field of jurisprudence has been understood since Hart, maybe since Kelsen, is far more significant because he challenges the very idea of legal validity. And beyond this, he challenges the way that legal positivists understand the relationship between law and morality, the relationship between jurisprudence and law, and between legal and political philosophy. Okay, so all this is very important for me to understand that as I see it, Dworkin's challenge is much more profound, whether successful or not. You may think that it's completely wrong, but it still has to be understood that it's not simply, oh, he has a different account of criteria of legal validity. Okay, so this is the part that is not in my paper, or kind of only hinted at in my paper, but I do want, maybe because I felt I'm presenting at Oxford, that I need to kind of make the case for it a little bit more. So Dworkin, so the question, what is law, can be understood in 3 ways. That's what Dworkin calls the taxonomical, the sociological, the doctrinal concepts of law. I really dislike both the fact that he calls it concepts of law and also the terms, but I think we can make sense of what he's saying in the following way. So if you're asking the question, what is law, we can understand it in 3 ways. The first one, which is the most commonly understood in contemporary jurisprudence, is the categorical or conceptual question. And so that's kind of trying to understand what law is regardless of anyone thinks of it. It's a pre-sociological question. And that's the mainstream view in analytic jurisprudence today. And I put names and places of publication of where this view, as I understand it, is being expounded. So it's in Gardner's Law as a Leap of Faith. That's in Les Green's Introduction to the Concept of Law, 3rd edition, and also in an essay published in 2016. It's in Shapiro's Legality. It's an essay by Marmor called Farewell to Conceptual Analysis in Jurisprudence. It's in Julie Dixon's Ours in a Broad Church, and you can go, I could have added many more. I think this view is ultimately traceable to Kelsen, and it sort of made its way to Anglophone jurisprudence through the early work of Raz, and so here I did mention Raz, which is, early Raz is very different from Hart. So Raz of the 1970s is much more Kelsenian than he's Hartian, and there's a very fundamental difference, as I see it, between the two projects. It's not a sociological project in any way. One way of seeing this, just kind of, if you want kind of a slogan way of seeing this, Hart talks about the internal point of view, which he says is a sociological, empirical fact. Kelsen and Raz both speak of the legal point of view, and both quite explicitly, I think, make it clear that they're not talking about the attitude of any individual. So that's a project. And I think that, and Dworkin says, and I think he's correct about this, that this is a misguided project. It's not, and let me be absolutely clear here. This is not a project that I think is uninteresting. I'm not going to police anyone on what they find interesting. Academia is full of people who do stuff that 99.9% of the world thinks is uninteresting. So, and I suppose that's true of what I'm doing as well. So I'm not saying this is not an interesting project. I'm saying it's a misguided project. And over the years, I've advanced various reasons why I think it's a misguided project, and I'll very briefly go over them. So here's one. If you think this is that's a viable project in the context of law, a pre-political, pre-sociological, purely conceptual inquiry about the nature of law, then why don't we do it for democracy, marriage, money, science, and I could go on, football as well, right? You could go, and pretty much every concept, definitely every social concept that's out there, you would have thought that that kind of project would be viable. And here I'll do a tiny bit of appeal to authority. I don't know if that's the right way of describing what I'm doing now, but consider this. So, sorry, where did it go? There it is. So here's a quote from an introductory book on philosophy of science. This is page 2 of that book. So it's very, very early on in the book. If we want to understand how science works, it seems that the first thing we need to do is work out what exactly we're trying to explain. Where does science begin and end? Which kind of activities count as science? Sound familiar? What counts as law? Unfortunately, this is not something we can settle in advance. There is a lot of disagreement about what counts as science, and these disagreements are connected to all the other issues discussed in this book. Okay? So now, I'm not saying, oh, simply because a philosopher of science said this must be true in the case of philosophy of law, but I'm just pointing out that if you think that this project of identifying what counts as law as an purely conceptual, purely analytical, pre-sociological project is true of law, you have to explain why this is not true across the board. Why are all philosophers of science getting this point so fundamentally wrong? Okay, so that's one argument against this view. In case you're interested, the book is Theory and Reality by Peter Godfrey Smith. Argument number 2, suppose you did succeed in identifying the nature of law. Okay, so you read the concept of law and you just said, yeah, that's it. Hart got it absolutely right. What follows from that? Well, I say very little, because all that you identified is a category. It still remains the case, remains to be shown whether anything in the world actually falls under this category, actually corresponds to this category, right? Because there are there's an infinite number of categories that we can identify, right? There's law, and there's law, and there's law 2 and law 3 and law whatever, right? So you can say Hart succeeded in identifying the nature of law in a pre-sociological way, and then just say whatever doesn't fit my category is not law. Well, we do know that people talk about this as law, and so there is something very problematic about the idea that you can do this and then just say, well, if it turns out that something that people practice in some place and they call law does not fit this category, well, that just doesn't matter, because it just means that this society doesn't have law. That's not how we would think about this, because it sort of, well, this leads to my third point of circularity, to which I'll get in a moment. But the point is that this kind of discovery is in itself useless unless you've gone forward and actually shown that anything in the world falls under it, and what in the world falls under it. And notice that there's one unwarranted assumption in this project, that everything that we call law belongs to the category to be explained. And if you say, no, I don't make this assumption, then you get to the third point, which is the problem of circularity, which is all views about what counts as the nature of law presuppose already what belongs in the category to be explained before they start the account. And anyone who doesn't agree with an account about of such an account of the nature of law can simply say, I don't agree with what you put in the category to be explained. I can give you multiple examples of this. So, for example, early on in Shapiro's book, Legality, he says, what bans have, and he says this way before he started his analysis, he said, what bans have is not law. Whatever it is that they have to regulate their behavior is not law. And that fits his account that comes afterwards, which is that law is a plan, because this whatever it is that bans have is not a plan. But of course, if we had said that what bans have is law, it would mean that Shapiro's account is false, right? So we have, in a way, the problem here is that we're trying to identify what law is when we have disagreement on two things. We have disagreement on what is the object that we're trying to identify and what's the theory that explains it. And since it's like trying to solve one formula with two variables, if you understand. There's an infinite number of solutions. Okay, so these are my arguments. This is not in my paper, but this is why I think Dworkin is right to say that this conceptual project is a failure. Okay, so back to the three concepts of law, as Dworkin calls them, or three ways of understanding the question, what is law? The second question is a sociological question. What it is that people mean when they say law? Now, I'm very much of the view, which is not very popular, I think, at Oxford, this is what Hart was doing. And I think there are many, many indications in the concept of law, as early as the preface, where he says, my project can be seen as descriptive sociology, and I think he very much meant what he said there, that this is what he was doing. And there are people who more explicitly say so. So Hema has an essay from 2007 where he says, what legal philosophers are doing is armchair sociology. Is very explicit about this. And Leiter when he tries to explain what Hart is doing, he says he's trying to explain the ordinary concept of law, which I understand to be what people mean by law. Now, and I understand Hart to think that what he was doing was sociology done right. This is the right way of doing sociology. So Hart was critical of the way sociologists were doing sociology, and he thought that ordinary language philosophy is the right way of doing sociology. I know that's a contested question. It's not really central to my paper, but I'm happy to talk about this if you want. That's what I think Hart was doing. And Dworkin says, and I very much agree, that that's not a way to do sociology. If you want to do sociology, then, go and ask people. I'm not just saying you should do surveys, but at the very least, you should start with trying to understand how people use it. And I'll just add one more thing. If indeed that's what you think you're doing, it's extremely unlikely, it's possible, but extremely unlikely that you'll end up finding that in all societies, in all times and places, and within society, everyone, lawyers and non-lawyers and so on, will have the same ordinary understanding of law. It's just not very likely. Because we know that from any other concept, people have different views and attitudes about it. So why would law be different? Why should we assume, which is, by the way, Hart's explicit assumption. He makes this assumption in the postscript. He says it's very explicitly that at the core, all law in all societies is similar. I say maybe it is, but that's the conclusion of such a sociological inquiry, not an assumption. Okay, so you'd say if we've ruled out these two, I mean, I don't rule out the second, I just say it should be done properly. But if we say these two ways of doing legal philosophy don't work, then have we run out of project? I say no. Here's the third one. We want to understand what separates law from what only has the external appearance of law, what is sham law, what is kind of, I don't want to say fake law, but sort of is kind of imitation law. Okay, so that's the idea. And here, again, this idea is not so radical. It has a long history, and it even appears in the concept of law, right? So when Hart says law is not the gunman situation writ large, you can read him as saying the gunman situation writ large may have all the outer appearances of law, right? You could put robes on the gunman and so on. It would still not be law. It would be something else. So there is something deeper to the distinction between law and robbery. And that's what we're trying to understand. And to show that this is not, again, a crazy way of understanding this. So here's an essay published in The Atlantic a couple of years ago. It says, America is not a democracy. Now, whether or not you agree with this essay, we can make sense of the argument of this headline, right? Because what it says is the US may have the outer appearance of the democracy, right? Free elections and free press or something like this. Whatever you think counts as a democracy. But when you dig deeper, see it's not really, right? It's a sham democracy, right? That's the argument. And just as we can make sense of it here, I say we can make sense of it in other contexts. And here it is in the context of law. We do talk about something being a show trial, which is not a real trial. It has the outer appearance of a trial. It will have judges, it will have procedure and so on. It's not really a trial. We can talk about the kangaroo court, which exactly is the same thing. And the picture is the People's Court in Nazi Germany, Freisler in the middle, which it's not implausible to argue that it had all the appearance of a court, right? You have judges and they wear, as you see, they even wear robes and all that, but it's not really a court, right? So if we can make sense of it in the context of trial or court, we can make sense of it in the context of law. And here it is, an example from a legal article by William Eskridge, published, not at all in this sort of jurisprudential context. One who has been declared an outlaw literally beyond the Constitution's protection is less likely to ascribe legitimacy to the decisions that condemn her. To us, Hardwick and the military exclusion cases are no more legitimate than Dred Scott. These decisions are not law because they deny us our citizenship and because they subject us to violence, right? So that's the sentiment. And again, I'm saying, Eskridge here is not making some kind of conceptual error. We can make sense of what he's saying. And that's a viable philosophical project. Okay, so that's what we're interested in here. And what I want to show, and that's important, is that if you understand this, the third type of question that we're interested in, then the inquiry at the sort of abstract level, what is law, has what I call in the paper downstream effects. And what Dworkin calls the silent prologue, right? Jurisprudence is a silent prologue of every legal decision. So this is another way, or one way in which this picture challenges the assumptions, the very assumptions of contemporary jurisprudence, which sees jurisprudence as merely observing the practice, not really participating in it, and not really and neutral about it. Whereas this understanding of the project of the question, what is law, and distinguishes it from what has the mere appearance of law, says, no, our answer to this question, even at the most abstract, may have downstream effects, may have effects downstream on our answers to particular questions. And that's what I will try in what follows to show you. Okay, so this is where I take a little bit of a change from the way I present the paper, but it's the same idea, don't worry. So here I'm kind of switching now to something that looks very different. So far I argued that Dworkin's way of understanding the question, what is law, makes sense. It's not a crazy one, and it doesn't offend linguistic practices, and it does not presuppose an account of legal validity, positivist or otherwise, right? So I did not, in order to say what I said so far about the distinction between what is law and what has just a mere appearance of law, but is not really law, it's sham law because it's illegitimate, I did not use the term legal validity even once. Okay, let's put this to one side for 1 second, and now let's move to talk about something that looks very different. So Mackey, in his great book, Ethics Inventing Right or Wrong, I kind of summarize his argument in a very kind of simplistic way. Here it is. For objective morality to exist, it has to be the case that certain things are thus and so. But in fact, they're not. The world is not the way that it has to be for objective morality to exist. Therefore, says Mackey, objective morality doesn't exist. Okay, that's a very simplified account of chapter 1, or part of chapter 1 of Mackey's book. I want to argue that Dworkin, in a way, answers to this question in the following way. You're right about premise 2. There's no morality out there. But you're wrong about premise 1. Objective morality doesn't, for objective morality to exist, it doesn't have to be this sort of out there thing, you know, part of the furniture of the universe. Okay? And now the question is, you'll say, okay, yeah, that's fine, but how does this in any way relate to jurisprudence? That in a way is what I want to argue, that Dworkin's answer to Mackey on this issue is also helpful for us for understanding his answers for jurisprudence, about how law, what distinguishes law from what only has the appearance of law, right? The question of legitimacy. And here, and this is again, just a brief remark about the fact that all that I'm going to say right now is actually something that naturalists about ethics should feel quite good about, because Dworkin's account, as I'll present it, is that to understand morality, it is a project of human construction. It is something that evolves through time, it changes, it has objective. There is a sense in which it's objective. It's not just personal preferences, but it's not something that exists out there that we discover, that exists before humans came to Earth or before the Big Bang, all this sort of stuff, right? And as I said, you know, that's something that naturalists about ethics have endorsed. And I put just a picture of the cover of just one book, Philip Kitcher's The Ethical Project, which is, I mean, it's clearly a naturalistic account of ethics, and it says, ethics is a project in which we're all participating in. It's ethics or morality has changed through time. And ultimately, I want to say this is what Dworkin is saying. I mean, Kitcher's book is far more detailed and in many ways better, I would argue, than Dworkin's account of Dworkin, of morality, sorry. And it's more explicitly naturalistic. But the sentiment that we can make sense of ethics as a sort of joint project, and that we can even make sense of ethics as in some sense objective, from a naturalistic perspective, is one that is found in works of naturalist philosophers. There are others I mentioned here that broadly explore this problem. And now I want to bring together these two lines of thought. Okay, so what is law? The one that I said, the third project, the law and legitimacy project, or what is law as part of an answer to what distinguishes law from sham law, and this project of making sense of ethical life as a kind of unified joint project. Okay? And I want to say this is Dworkin's project in the biggest sense. Okay, because one thing that's, for example, I'll add just one thing. If you read Kitcher's book, one thing that's interesting about it is the very small role that law has in it. So law is this kind of joint project in which we're kind of developed through conversation and discussion and so on. But law is barely mentioned here. And you can understand the project as one way of contributing to this project is saying, actually, law is very significant to this ethical project. And now I get to what is in my paper quite early on. This is what I call the basic picture. I'm not going to read all of it, but I say this is a sort of these are sort of basic assumptions that I think underlie most of contemporary jurisprudence. But it's sort of assumed, often without really that much of an argument, that everyone accepts 1 to 6. There's some disagreement on 3. I have to say this, but by and large, there's agreement on 1, 2, 4, 5, and quite a bit of agreement on 3. And then the only real disagreement is on the nature of the criteria of legal validity, right? So it's not on the criteria themselves. Of course, Brazilian law, the criteria of validity in Brazilian law are different from the criteria of validity in Greek law. But the nature of those criteria of legal validity is the same. And that's what distinguishes the law from non-law. Okay, so much of the debate in contemporary jurisprudence is on point 6. And I want to say, and everyone, and it's mostly assumed that Dworkin accepts 1 to 6. Some people say he actually rejects 1, right? Law is not actually human creation for him. And I say, no, Dworkin definitely accepts 1, but he rejects 2 to 6. Morality is a human creation. Morality and law are not separate because they're kind of a joint project. Morality is not exactly the benchmark to law. We'll see in what sense they relate to each other. And there is and what distinguishes law from non-law is definitely not criteria of legality. There is no such thing as criteria of legality by which you identify things as in the world as law. Okay? And so what does that mean? So at the most fundamental point, the most fundamental way of understanding this is for Dworkin, humans engage in morality or objective morality is the product of constructively interpreting moral practice. And this may sound shocking to anyone who thinks that for Dworkin is a hardcore moral realist, but I suggest that you go and read his review of A Theory of Justice, which is chapter 6 of Taking Right Seriously, where he contrasts 2 models of morality. He calls them the natural and constructive, and it's quite clear that he favors the second, the constructive. And the constructive model of morality, he explicitly says, is something like the common law. It's one in which what morality requires is a matter of constant debate. And he explicitly says, in my account, morality can change. Morality is contested. It rests on some agreement, foundational agreement, but it's very much contested. It doesn't undermine the possibility of objective morality. Okay? So I argue that all those who say, oh, in Justice for Hedgehogs, Dworkin has this new idea of law and morality being one domain. No. It's already in 73 when in Dworkin's review of roles and in other chapters of that book. So humans construct morality in this sort of discursive way. And that is also how they develop in law. And this is the important point. Law is a major participant in this project of constructing morality. And if you understand this, you have a story to tell about what makes law legitimate, right? Because law is a mechanism for, it's one aspect of this moral project, ethical project in which we participate in, and its significance is that it relates to one aspect of this ethical project, which is the coercive part, right? This is why it is fundamental for Dworkin that law is a coercive enterprise, right? Law tells people what to do and forces them what to do in a way that, the rest of ethical discourse does not. And if you understand law in this way, jurisprudence in this way, then I propose we can understand legal theory not as a matter of legal validity, what are criteria of legal validity, but as what makes law legitimate, what gives law authority. And I then say, if you say this, we have a different way of understanding legal positivism and natural law. They're not something about necessary connections between law and morality, but two competing accounts about what makes law authoritative. Broadly speaking, legal positivism is a will-based account, and natural law is a reason-based account. Now, if you accept this, that legal positivism and natural law are not competing account, they're not sort of one is a mirror image of the other, one is a negation of the other, then it opens up the possibility for other accounts of the authority of law. And here's another one, community. And that's what I call, it's not original to me, common law theory. Here there's very important work by Brian Simpson and Jerry Postema, and less important work by me that tries to explain what this idea of common law theory is. At its foundation is that the authority of law comes from the fact that it reflects the values of the community. Okay, and once you understand this, quite a lot of what Dworkin says makes sense. So here are some hints that Dworkin is a common law theorist. So he talks about law as a seamless web. He talks about law working itself pure. He talks about the fact that law is not quite invented, but not quite discovered. It's this sort of interpretive enterprise, right? Which is just like what we do with the common law. We constantly interpret it. He's clearly distances himself from reason-based, sort of classical Thomist accounts of natural law theory. He rejects more realism while insisting on the objectivity of morality. He has a constructive account of morality, and he has a constructive account of law. And in a long footnote, I also say that all kinds of other things that may have puzzled readers of Dworkin, for example, his views on international law, make sense once you understand him as a common law theorist. Morality is a joint project in which members of a community participate, and law is a major perhaps the major participant, major mechanism by which this enterprise of law/morality making happens. Am I talking for too long now? I think I may have.
Yeah, it would be a good idea if you could.
Okay, so I'll stop. So it does mean I haven't spoken about theoretical disagreements, which may interest you. So if you want to ask me about that, I'm more than happy to talk about that. But I'll stop now. I'll just say thank you.
Okay, so Dan, thank you very much
I'll
for this.
stop the share.
Yeah, sure.
Okay.
Thank you very much for this intriguing presentation. I'm sure there are many questions. We will stop now our recording and we'll move to the Q&A section.